Hello, my name is Rachel Vahey and I'm a Senior Technical Consultant here at AJ Bell. Today's webinar is covering powers of attorney and deputy orders. At a time when people are living for longer, the importance of having a power of attorney in place is growing. Not all of us will enjoy a healthy old age, and we all face the possibility of losing mental capacity and not being able to make our own decisions about care and treatment, but also being unable to manage our own financial and domestic affairs. If this happens, we want to make sure the right person is fighting our corner and looking after us. The sad truth is the charity Age UK estimate that over 130,000 elderly people are victims of financial abuse by a family member or someone they know. And those with dementia or reduced cognitive function are the most vulnerable. There is obviously a strong link between establishing a power of attorney and vulnerable customers. Vulnerable customers is an area which is strongly within the sights of the FCA. So it makes sense for advisor firms to consider powers of attorney as part of their vulnerable customers policy and the help that they give these clients. But it extends further than that. It's not just about setting up a power of attorney for those people who are vulnerable, who are on the onset of dementia or reduced cognitive function. It's about putting these things in place before that becomes an issue. So what I want to do today is to go through the learning objectives for this webinar. It's to understand the three main types of power of attorney and how they differ, to describe how the system works in Scotland and Northern Ireland, and to identify what a trustee power of attorney is and what to do if no power of attorney is in place. So that breaks down into three main areas. Let's start off by going through the basics, look at the different types of power of attorney, and then end with deputy orders. So what is a power of attorney? Well, this is the legal definition. A power of attorney is a legal document by which one person, the donor, gives another person, the attorney, the power to act on their behalf. An individual can generally do whatever they want with their money and their property. Whether it's a good decision or not, we all have that freedom and liberty. But with a power of attorney, you're handing that ability over to another person. So this is a really powerful mechanism. Now, there are safeguards in place, but choosing an attorney is not a decision to be taken lightly. A power of attorney can be used in respect of financial, personal, and welfare matters. But we're going to focus on the financial side of things in this webinar. So, a few key points. You can only set up a power of attorney if you've got mental capacity. Now, mental capacity or incapacity is something that we're going to come back to several times, as this can affect the ability to set up a power of attorney and also the validity of the power of attorney after that. Its definition is if the person is unable to make a decision for themselves in relation to the matter because of an impairment or disturbance in the functioning of the mind or brain. So that's really quite a formal definition. And the trick can actually be understanding if in the terms of whatever legislation and the piece of legislation, whether the person actually has mental capacity or not. You can appoint more than one attorney. They can act jointly. And if they do that, then both attorneys must agree on the decision. Or they can act severally or separately, and each attorney can give an instruction. There could be restrictions. A power of attorney could be restricted to certain types of decision, but it can't make some decisions joint decisions and some decisions several. No power of attorney prevents the customer from continuing to give instructions. The most recent piece of legislation surrounding this area is the Mental Capacity Act of 2005, which has an accompanying code of practice. And the code says that individuals must be assumed to have capacity and, where possible, be supported in making their own decisions. This system is not one without safeguards. There are 5 statutory principles, and one of those is that the attorney must make decisions in the donor's best interests and that they cannot delegate decisions. Now, this code of practice, it goes into quite a lot of detail on this area, including what best interests mean. When you're looking to appoint an attorney, you really want to appoint someone you trust and someone who will always do the right thing by you, and you can be assured that they're always going to act in your best interests. There's no need for the attorney to move customers' money into their own account. So we're not expecting a power of attorney to get in touch with a provider and say, I am going to move this person's money into my own account. Nor would we expect to pay out withdrawals to someone else's, to a power of attorney's account. We would expect just to continue to pay it out to the customers. And certification and certified copies. There are specific rules around this area, and this comes from the Powers of Attorney Act 1971. The power of attorney can be certified by the donor while they have mental capacity, or a solicitor or a notary public. The person certifying it must include their full name, and every single page of the document must be signed, dated, and contain the wording stating it's a true and complete copy of the corresponding page of the original. And then the final page must state, I certify this is a true and complete copy of the lasting power of attorney. So let's go on now and have a look at the different types of power of attorney. Broadly, there are 3 different types: ordinary power of attorney, lasting power of attorney, and enduring power of attorney. Let's start with the ordinary power of attorney. Now, this is the oldest type of power of attorney, and it's also referred to as general power of attorney. It can provide the attorney with general authority over the donor's estate, or you can limit it. You can limit it to, say, particular transactions or for a particular period of time. It has a narrower remit than other powers of attorney because it can be used for property, investments, and financial affairs, but it can't be used for personal welfare. An ordinary power of attorney terminates if the donor or the attorney dies, or the attorney becomes mentally incapable, or the attorney is declared bankrupt. Otherwise, it carries on indefinitely. It will usually be a simple 1-page document. It comes into effect immediately, and it doesn't have to be formally registered. It just needs to be executed as a deed. It can only grant power to one attorney. So if you want more than one attorney, then you have to have more than one ordinary power of attorney document. Where it's really useful is for short-term purposes. So for example, where it could cover the period when somebody is on holiday, or they are on extended leave outside the country, or they're working abroad, or maybe they're going in for a big operation and they know they need someone just to look after their affairs for a very limited amount of time. The second type of power of attorney is a lasting power of attorney. Now, this is the newest form of power of attorney, and it's the one that clients who are setting up power of attorney now will be looking at. It was introduced by the Mental Capacity Act of 2005, and it came into effect in October 2007. And as I said earlier, there's a code of practice to go along with this particular act. The code isn't strictly speaking legally binding, but legislation requires attorneys to follow the code of practice. It's extensive, I won't lie to you, it's a big read, but it's worth the attorneys looking at it and knowing exactly what they've got to follow and having a look at what the code sets out. Okay, so there are two types of lasting power of attorney. The first one is health and welfare, and that appoints attorney to make or help the donor make decisions about their daily routine, their medical care, and even things like where the donor lives. For example, if the donor is moving into a care home, which care home, and decisions like that. The second type relates to property and financial affairs. The Office of the Public Guardian, the OPG, provides specific forms that we've got to fill in to apply for a lasting power of attorney. Now, these are between about 11 to 16 pages in length, so they're quite big, quite bulky. People can complete the forms themselves. Most of it's online, but they could also ask a family solicitor to help them with the process and with completing the forms. With all these sort of things, there's lots of legal jargon and hurdles and things like that. So people sometimes need help to understand them all. A donor can appoint more than one attorney, and they should choose whether they want their attorneys to act jointly or whether to act separately. They can also appoint a replacement attorney. Now, you might want this in a situation where the attorney that you appoint is maybe elderly or in poor health, and you worry about what's going to happen to them, especially when you think how long a lasting power of attorney, what time period it could last for. So if that's the situation, you may want to appoint a replacement power of attorney to act in case an attorney cannot do that. Finally, I'm just going to mention the certificate provider. Now, the document has to be signed by an independent person. This has to be an impartial person who is confirming that the donor understands what they're doing and they're not being pressured to make a lasting power of attorney. So they're assuring that there's no fraud going on, there's no reason for concern, that the donor isn't being coerced into a particular action and to give away the powers over their financial property. There are two types of person who could be a certificate provider. The first one is that they could be a friend or a colleague who the donor has known well for at least 2 years. Or you can appoint a professional. You can ask a professional to be a certificate provider. And they have the skills to judge whether the the donor understands what they are doing and whether they're being unduly pressured to take this action. So an example of a professional could be a GP or a social worker or a solicitor. If you're going to look at a friend or a colleague, then it can't be a family member. The certificate provider always has to be over 18 for both cases, and you can't ask a paid employee to do it either. Now, there's pros and cons with both of these. If you ask a friend or a colleague to do this, then you won't be paying any fee, or we presume that you're not paying a fee for them to do it. But if you ask a professional, then that might be better in the long run. If somebody could challenge the lasting power of attorney later on, and if that's the case, then the certificate provider would be called to the court of protection, and they would have to justify their opinion on why that person had the mental capacity to set up the lasting power of attorney and why they weren't pressurized into doing so. So the person who's the certificate provider has to be able to assess mental capacity in terms of the Mental Capacity Act of 2005. So it could turn out to be quite a big ask, maybe not something that you're just going to ask your neighbour to do. So a lasting power of attorney has to be registered with the OPG, the Office of Public Guardian, from the outset, or it's not going to be valid. Now, at first sight, you think, oh, this is extra administration. It's got to be an extra fee. You have to have a court registration fee. But in the long run, it's going to make the process a lot more consistent and straightforward, especially when we get to that crunch point when the donor loses mental capacity. At that point, you just want to be able to have control over their affairs and to be able to, there'll be so much to sort out, so much administration and financial issues to sort out. So it's, in the way, registering it up front means it's a lot easier when that crunch time comes. The lasting power of attorney comes into effect once it's registered, but you can include restrictions. For example, you can say, I don't want it to be used until I have lost my mental capacity. And I think that's going to be a lot more appealing to people. Some people are going to be very worried registering something at outset and thinking, well, I'm giving away these powers and I'm delegating these powers to my children or to my niece or nephew now, and I don't really want to do that. I'm a bit worried about that. But it's not the case. So you can write into the power of attorney that it's to the use only starts once they have lost their mental capacity. The lasting power of attorney remains in effect on the loss of capacity as well. Now, it may automatically end if the attorney dies or loses mental capacity or becomes bankrupt, and they are a property and financial affairs attorney, and there are no replacement attorneys to take their place. A lasting power of attorney can be changed by the donor if they still have mental capacity, and they can do this by contacting the OPG and providing certain documentation. But if the donor wanted to add another attorney, then they would need to end the lasting power of attorney and make a new one, again, while they still had capacity. To end a lasting power of attorney, the donor must send the original documentation to the OPG, and that way that they'll be able to bring it to an end themselves. How to tell whether someone has capacity can be difficult. The areas that you're looking at is really whether they can weigh up the pros and cons of a decision, whether they understand the kind of decisions that are going to be made, and whether they're able to communicate clearly what they want to happen, even if that's just through blinking their eyes or squeezing a hand. So that's lasting power of attorney. Moving now on to enduring power of attorney. This was the one which was the predecessor of lasting power of attorney. It's been around since the 1980s, but you're going to still encounter clients who have got one of these in place. You can't any longer set up a new one, and that's not been possible since October 2007. But if there is one, and it's been signed before October 2007, it can still be used. Now, while the donor is mentally capable, an enduring power of attorney operates in exactly the same way as an ordinary power of attorney. It can be used for property, investments, and financial affairs. Again, enduring power of attorneys, they don't apply to personal welfare. So if the donor still has capacity, they may wish to consider making a lasting power of attorney for just for the health and the welfare side. The enduring power of attorney is effective immediately, and while the donor is mentally capable, an enduring power of attorney operates in exactly the same way as an ordinary power of attorney. But if the donor loses their mental capabilities, then the enduring power of attorney can only remain in force if the attorney registers it with the Office of Public Guardian. And until it's registered, the attorney isn't authorised to manage the donor's affairs. So you're having to make a decision at the time when, as I said before, it's a difficult time, lots of things are happening, but that's the point that you then have to register the enduring power of attorney with the court. If the enduring power of attorney was registered before October 2007, then it's going to show the stamp of the Public Guardianship Office, not the OPG. If the enduring power of attorney hasn't been registered, it may still be used if the donor still has mental capacity and there are no limits on the attorney's powers. For example, there's no wording that states the powers are only effective on the donor becoming mentally incapable. And to cancel an enduring power of attorney, the donor can complete a deed. The attorney must be notified of the cancellation as well as the OPG if the enduring power of attorney has already been registered. So, I've spoken so far about the English law and practices, but of course we have devolved powers and different legal requirements in different parts of the UK. So the situation is going to be slightly different for both Scotland and Northern Ireland. Ordinary powers of attorney in Scotland and Northern Ireland are broadly the same as in England. But the concept of a lasting and enduring power of attorney doesn't exist in Scottish law. Instead, they have a continuing power of attorney in Scotland. Now, for continuing powers of attorney made after April 2001, the deed must expressly provide that the attorney's powers can continue beyond the donor's incapacity. They have to be registered with the public guardian once the donor has lost capacity. In Northern Ireland, we have just a slightly different type of enduring power of attorney is used, and it can become effective immediately or only after it is registered, and that really just depends on how the donor would like to set it up. Either way, it needs to be registered on incapacity. So I've just been through the three different types of power of attorney: ordinary, lasting, and enduring. But there is another one, which is a trustee power of attorney. Now, this is for people who act as trustees. Wider trust law means that if an individual becomes mentally incapable, then they cannot act as a trustee and they cannot delegate that power. However, there are still situations where somebody who has capacity and is acting as a trustee, they may still wish to delegate their trustee decisions for a limited period of time. So again, if they are going abroad to work abroad for a period of time, or they're traveling, or they're facing an operation and are not going to be well enough to act as a trustee for a limited amount of time. Now, because they're a trustee and they cannot delegate their powers, they cannot do this under a conventional power of attorney. They can only do it using a trustee power of attorney. Now, this is covered by the Trustee Act of 1925, and that gives us a specific wording that has to be used for the trustee power of attorney. It needs to be executed as a deed, so in other words, signed and witnessed. A trustee power of attorney only lasts for a maximum of 12 months. And after that, a new trustee power of attorney must be executed. Unlike an ordinary power of attorney, a trustee version does not automatically terminate on the mental incapacity of the donor. Now, this is particularly relevant where you may have clients who have a full investment SIP. And in some situations, they may be co-trustees of that SIP. Or, for example, where they have SASs as well. So it's worth looking at a trustee power of attorney for those particular clients in some particular situations. Okay, so those are power of attorney. What I want to look at now is what you do if there is no power of attorney has been set up. Now, you're going to be working with your clients to make sure that they're aware of having a power of attorney in place, a lasting power of attorney in place, but you are naturally going to meet some people who don't have this power of attorney, but who have lost their mental capacities. In this case, an application has to be made to the Court of Protections. Now, this is a specialist court that deals with issues relating to people who lack the capacity to make their own decisions about property or financial affairs or health and welfare. The Court of Protection can make decisions on somebody's individual matters, or they can appoint deputies to make those decisions. So if an individual becomes mentally incapable, but they don't have an existing power of attorney in place, then a legal representative or a relative or a friend can ask the Court of Protection to make an order appointing them as a deputy. And in this situation, solicitors are often deputies. Now, the terminology is different, but a deputy essentially acts as a court-appointed attorney. The OPG has responsibility for ensuring, for supervising these deputies and just for making sure that they don't abuse their own position. And that really means that the person who's acting as the deputy has to report back to the OPG, that they have to go back and say what they are doing and give them an account of their decisions. And they also have to pay a fee for them to supervise them. Now, this process can be extremely costly and it can be time consuming, both initially and on an ongoing basis. And as I said, it's at a very difficult time. So you may have a situation where the spouse or partner is left in a position where their loved one has lost their mental capabilities and they're unsure exactly how to, they haven't got control over their financial affairs. They may have completely separate bank accounts. One of them could organize particular financial elements within the couple, and so they need control over the financial affairs of their loved one. And it could be that they've lost capacity when they didn't expect it. It could be completely unexpected. If you can see that someone is getting older, or that you are worried about dementia or some other medical condition, then you might seek to put a power of attorney in place where they still have mental capacity. But this could be a situation which has been really unexpected and forced upon them, and they are dealing with all of that and the fallout from all of that. And that's the time that they then have to approach a court. And it's very administratively heavy. They may have to pay legal costs to help understand how to apply for this, for powers to be delegated. And this could come at the same time they're trying to sort out all the medical care for their loved one, or sorting out new residents like a care home. So deputy orders are really a backstop. It's only where there are no power of attorney, but putting in place a power of attorney ahead is obviously a better solution. So what I've covered today, and hopefully what you've learned today, is that there are three main types of power of attorney and that they all differ. You're able to describe briefly how the system works in Scotland and Northern Ireland. You can identify what a trustee power of attorney is and what happens if there is no power of attorney in place. I think hopefully what I've demonstrated today, that is setting a lasting power of attorney, is an important part of financial planning. It's not only when we worry about somebody losing their mental capacity, it's almost recognizing that this is an important part of the financial planning jigsaw that really needs to be in place from quite an early stage. And it's encouraging people to take this action. Nobody likes to face or likes to contemplate losing their mental capacity, just like they don't want to think about dying. But unfortunately, it can happen so quickly, and falling ill can happen so quickly. And it is better really for people to be prepared and to face that, and to be assured that if it does happen, then they have got the right people acting for them. I really hope that you found this useful. Thank you very much for tuning in, and take care. Goodbye.